Welcome, everyone. This is Ask the Experts, and we have our guest speaker on today is Shawn. He is a lawyer, and he's going to be talking to us about joint venture agreements. So it's going to be a lot of fun to get a lot of answers because I feel like the legal side is always so scary. So it's awesome that we can have you on, Shawn. Thank you so much for coming on.
Oh, thank you for having me, Diane.
So do you want to just start? Let's start off with just a quick, tell us a little bit about yourself.
Sure. So I am a real estate investor lawyer with Carson Law. You may have heard of us if you're an investor. We are real estate investor lawyers. We work almost exclusively with real estate investors, and you may have seen us on various channels and all over the social media. So. And we enjoy that. We at Carson, Ryan Carson and I are both real estate investors. I've been investing since I went to law school way back in 2015. I started completely by accident and by house hacking. I didn't know what that was or what I was doing, but I know I needed to generate some sort of cash flow while I was in school. And so it's really taken off from there. So I've been investing for 6 years almost, and transitioned my law practice into real estate investing law so that I could mesh my interests in my profession. And it seemed like an area of law that wasn't really being serviced properly by lawyers. You've got your real estate lawyers and your corporate lawyers, but not every lawyer can speak the language, the real estate investing language. And so it seemed like a natural fit, and so far so good. It's been awesome. The market's really responded to the value add that brings, and that's it. So that's about me.
Thank you so much. Yeah, and just to make a point, I think it's very true because even if you do have a lawyer that's related, let's say, to real estate, but when you're talking about the investor side of things, even that is just a different sector because I've had lawyers before that weren't investors, and I think they're a lot more cautious. Basically, like I would tell them things, and they're just like, like, "What are you doing? Is that normal or something?" So it is definitely nice to have an investor-related lawyer on the team. So let's get started with the first question, and let's start with just something super basic, just that everyone knows and understands. What is a JV, and just a little basic of what it is and why we'd use it.
Sure. So a joint venture partnership is not a partnership in the legal sense. It's a partnership in the practical sense. We won't get into partnership law because it's a little in depth and it's not really applicable. But what it is really is the pairing of two or more entities that want to work together to create some value somewhere and ultimately be profitable, generate cash flow, generate equity, generate wealth. And so what it is, in essence, is a contract that sets out how each party is going to contribute to the overall goal and how we're going to have our relationship as partners governed. So that's really the basics of it. So what you're going to see is two people, typically, sometimes three or more, but it really depends on the deal, get together and figure out what each can bring to a particular deal. I'm sure many of you have read Money People Deal by the late Stephen Arnio. And that book really encapsulates what it means to be a joint venture partner, because really it's the pairing of people with money that know people and with a deal. And so we would see joint ventures exist where one party doesn't bring that complete package. I might have 5 deals in the pipeline, but if I don't have the cash to close on all of them, I need a partner. Otherwise, I'm getting zero. And as the quintessential saying goes, I'd rather have half of a grape than none of a watermelon. And so that's really what joint venture partnerships sort of allow or create is this ability for two people to share their resources and ultimately benefit themselves and together.
100%. That's great. And so now that everyone gets a general understanding of what it is, let's get into the different types of, I don't know if you call it clauses, but clauses that you see in an agreement. Like, is there any standards that we should definitely have in there when we're talking about a joint venture agreement?
Well, I could probably talk for an entire day about all the different clauses you can put in. So let's start with the basics. Number one, we can go as in-depth or as simple as you want, right? Like I have a joint venture agreement that I work with that's 30 pages long, but I also have one that's 6 pages long. They accomplish the same thing, but they don't build out the relationship as much, on the shorter one. We've got a much more simple understanding. This would be something you would use probably for a shorter term project or for someone like a family member or someone you're really close with. But if you're finding partners in the community and you don't necessarily know people, then I'm going to always recommend that we use the built out version of that deal. And the reason we do that is because, it's exciting to talk about deals. It's exciting to look at cash flow projections and equity projections. And where are we going to be at 5 years? What's our return on investment going to be? And it's probably going to be huge. And that's very exciting to talk about. But the reason you build a joint venture agreement is to deal with all of the scenarios that aren't exciting, that are mundane, or worse, not great, right? Not everything goes perfectly. As we all know, no deal goes perfectly. There are always road bumps. So we want to make sure that we build out a process for dealing with those speed bumps, with those bumps in the road. So what you're going to look at in terms of what you want in your joint venture, well, number one, who's doing what, right? Who is bringing the money? Who is going to go on title? Those are probably going to be the same person. Who's going to run the project? Who is going to source the materials? Is it a flip? Is it a burr? Is it a wholesale? I've seen a joint venture deal on a wholesale deal. Instead of a finder's fee, maybe we have something a little more equitable in terms of a split. So that's where we want to start. What's everyone bringing to the deal? Because everyone's bringing something, right? Otherwise, we wouldn't do the deal. So we want to set out what everyone's going to do, when they're going to do it, and what they're responsible for. And that can be built out broadly in the sense that we don't have, a 10 bullet point list of all the things that the active partner is going to do. We would probably be more likely to describe it generally so that we capture more things. And if you think about it, if you're the passive partner bringing money and mortgage qualification, you want as much captured by the description of what the active partner is doing as possible, because that's not what you're bringing to the deal. And you don't want to be stuck having to do things that the active partner, who's not bringing any money, should be doing. And on the active side, we want to set out how much money is at minimum being brought to the deal, right? We don't want our passive joint venture partner to show up with $30,000 less than we need, because that could kill the deal, that could cause legal consequences, all sorts of gnarly things that we don't necessarily want. So we're going to want to set out what money needs to be brought. And I'm not just talking the down payment. If there's got to be construction money coming in, then we need to make sure that we add that probably as a separate line. And we're going to want to bring a term about mortgage qualification. Who's going to hold title? And is that title being held in trust? Now, we're going to get to that, I imagine, probably a little bit later on in terms of how we secure our relationship. So I won't get too much into it now, but ultimately, you're going to want one partner holding the property in trust for the other. As we build out our contract and our relationship, we want to set out sort of how we're going to deal with those speed bumps I mentioned. How are we going to deal with the issues that come at us as we're progressing through, our flip or our burr, et cetera? How are we going to deal with tenants? Are we going to outsource to a property management company, or is the active partner going to do the property management himself or herself. So that's a real basic understanding of the terms that we would want to bring to a joint venture. Of course, that doesn't capture 30 pages worth of terms, and I could go on for days. But this is a general sense. This is what, before you call me up or you call Ryan up or another lawyer, if you're working with another lawyer, you want to have a basic understanding of these things so that your lawyer can help you draft a contract as efficiently and hopefully cost effectively as possible.
Great, thank you so much. That was really insightful. And see if does anyone have any questions that they would like to ask? Feel free to put up your hand or unmute.
I do.
Yeah, go ahead, April.
When one party has their lawyer drawing up the agreement, the joint venture agreement, is it normal that just one party pays for it, or do both parties need their own lawyer? In other words, one lawyer to draw it up and one lawyer to look it over, so the interests of both parties are, I guess, taken care of?
April, great question. This is a very common question, and I'm so glad you asked it because this is a really important thing to understand. Our process is, at least at my law firm, I'm going to get on a video call just like this with you and your other partner or partners. And I'm going to hear about what the deal is. What's the strategy? What's the exit strategy? Who's bringing what to the deal? And I'm going to get a general sense of that. Right. And then I'm going to go back after a call and I'm going to write, I'm going to draft, right? That's what I do. And then I'm going to present all of you with the first draft. And you're going to have a read through. And if it captures the deal that the two or more of you agree to, great. That's just the start though. Okay. I only have one client. I can only represent one of you in this deal. There's what we would call a bright line rule against conflicts of interest, right? I couldn't very well represent two or more people in the same deal because that's a conflict. So two things can happen. Number one, you go get independent legal advice and you come back with your certificate. Now, independent legal advice is going to involve hiring another lawyer. They're going to review the contract with you, explain the terms, especially the ones that could have a negative impact on you. And let's get it out there. A contract is a contract. There are pros and cons to entering into it, but we are venturers, right? It's written in the name. We're in a joint venture. And so there's going to be some downside. There's going to be some risk, right? Like if you are the passive partner and you don't pay the mortgage, that's going to be on you, right? And you're going to have to, sort of cover the costs associated with that. So your independent lawyer is going to review the terms with you and make sure that it encapsulates the deal that you thought you were getting into. And they might have some suggestions about tweaks or edits. At the end, once you're satisfied and they're satisfied that you're satisfied, they're going to issue you a certificate of independent legal advice, which you would then bring back to me. And that makes sure that I know that you have gotten some independent advice, and that you're comfortable entering into the deal. It also covers my butt, right? Like I'm trying to help people, but I can't put my license on the line to do that. So that helps me sort of stay within the guidelines of the Law Society's rules. There's another option. And if you're a sophisticated partner and you're comfortable with this, you can waive independent legal advice. Now, I'm not going to ever recommend that you waive it, but if you're comfortable, if you're ready to go, then you can waive it. But I'm going to get you to sign a waiver because it's the same sort of thing. I got to know that you're comfortable enough, and you have to acknowledge to me that I've encouraged you to go get independent legal advice, client. And that's okay too. That's an individual choice. Now, independent legal advice probably costs you $500 plus HST and maybe a storage disbursement. So it's a pretty cheap insurance policy when we're talking about assets worth hundreds of thousands, potentially millions of dollars. But it's up to you. Ultimately, though, everyone does need the opportunity to seek independent counsel.
Awesome. Thank you so much. April, do you have a follow-up, or did that answer all your questions? Did that answer everything for you?
Yeah, of course I have a follow-up. Sorry. It's a generalized question.
Sure.
But if you have two parties that have come to the agreement, they've each got their legal representation. If we're talking a simplified 6-month deal where the money partner's just loaning it for the flip in order to wholesale it, what range would you say legal advice or would cost? In other words, I know it's going to depend on how many times it goes back and forth between the lawyers and the parties, but let's just say it goes back and forth twice and that's it.
Do you mean to draft the agreement?
Draft it and sign
revise?
off on it.
Yeah.
Notarize it.
Well, I can't speak for any other lawyer, but I can speak to what our firm charges. So to draft the joint venture agreement, we charge $1,500 plus HST and disbursements, which there are a couple. So that will get you, first meeting with me. We'll probably be on camera for an hour, and I'll listen to you and sort of take notes, get a sense of what the deal is. Then I'll go and write it up. Then we'll get on another call to review. That's what that gets you. Now, if you need something like way out of normal, right? Like then that's going to incur some additional costs. But ultimately, my goal is have 2 meetings. One to figure out what you want in your draft, and the second to make sure it's in there. And then that would get you pretty close to across the finish line. If we start getting into lots of back and forth, then obviously the cost is going to go up from there.
Thank you so much, Shawn. What about, I know that Andre has a question.
Andre.
Yeah, quick question. Shawn, can you touch on timelines, maybe best practices in terms of when we should be approaching the lawyers? Is it when we have a deal, when we found a joint venture partner, or I guess how that works?
Great question. There's so many ways to answer this question, and it really depends on your tolerance, right? So here's a common misconception. Let's say you get into a deal and it doesn't close. There's still going to be legal fees, right? It all doesn't just disappear. So what happens is, if you come to me too early and you get me drafting and then the deal doesn't go through, I've still got to send you a bill. You're going to have a product at the end, but it's not going to be that helpful for you. At least not until the next deal, in which case it can be sort of reworked. But I guess that's an intro to say, get me the deal as soon as your real estate deal is firm, right? Unless it's a quick closing. We're good at Carson Law, but we're not miracle workers. And, lots of people are really interested in having us represent them, which is great. But it means we have a lead time. And so, for turnaround time, I need at least a couple of weeks to schedule a meeting with you, review sort of your intake, and then actually get to drafting. So generally, we're going to need at least a couple of weeks. So if you have a period of time between going firm and closing of at least 2 to 3 weeks, then you're going to be in the comfort zone. If, however, you've got a really tight closing, then you're going to need to get it to me sooner or be comfortable enough to have it done after you close. And that's really going to depend on your relationship with your partner and, of course, what partner you are in the deal.
Perfect. That answered it.
Awesome.
Great.
Does anyone else have a question that they would like to ask? Going once? Going twice? Okay, I'm going to ask the next question then. So when we have our JV created, what can we do to, if something goes wrong or something isn't followed, is there a way for us to secure or make sure that the JV is being followed?
Yes, and it really depends on how you draft your agreement, right? So that's what I was mentioning earlier, right? The reason you go talk to a lawyer is because our job is to think about all the things that could go wrong. And while you guys are sourcing deals and funding deals and creating partnerships and doing great things, you pay me to make sure that I cover your butt if something goes wrong. And so what we do is we build in sort of processes. If person A does not do X, Y happens. So in a joint venture, this can happen in a couple of ways. Number one, the active partner doesn't do what they're supposed to do. Well, we can write in whatever you want, right? Like whatever the 2 or plus partners agree to, we can draft, right? But you want to think about that. What if the active partner doesn't do what they say they're going to do? Do we take away their cash flow? Do we penalize them? You don't necessarily want to write a penalty clause into a contract because the courts don't really like to see that. And if this ever got to court, then that might not be something that's all that enforceable. But we can draft it another way. And that's probably going to be taking away the cash flow from the active partner. Is it the passive partner not putting in money when required? Well, we can figure that out as well. Maybe the active partner lends the money and earns an interest rate. And if that money is not paid back, then we register a lien on title so that it's eventually paid back when the property is sold. So there are a number of ways to sort of make sure that we have people doing what they're supposed to be doing. But generally, this is not going to be something that we're going to be concerned with because we enter into this deal to take action and to achieve wealth. And if both parties aren't doing what they're supposed to be doing, then that's not occurring. And you sort of have to rely on each other to do that, right? The passive partner has to bring the cash or the property doesn't get purchased and the renovations don't get done. And the active partner has got to get the property from its worst state to its highest and best use and has got to make sure that we get tenants in and get cash flowing. Otherwise, there's no cash flow and we aren't generating wealth. So, that's the beauty of the joint venture. It sort of requires each party to fulfill their role such that each party can also benefit.
Awesome. Great. It's a great answer. So does anyone have any questions? Would you anyone want to have a follow-up to that? Yeah, go ahead, April.
What would that follow-up agreement with the penalty clause be called? Like just a penalty clause agreement, joint venture agreement after the main agreement is in place?
No, it's built right into your joint venture contract. So these would be the terms of the deal. So, if you're the active partner and it's your job to manage the renovations, then we're going to build in a report. You got to report to your passive partner at a certain frequency. Maybe it's monthly, maybe it's weekly, maybe it's twice a year, and you've got to show the progress. Now, do we think that the passive partner is just going to hand over $150,000 and go away? No. Of course, they're going to be checking in. So this sort of takes care of itself because if you're a passive partner, you want to know what's happening. You want to make sure that there's going to be a good rental so that we can get refied and we can get our capital back and move on to the next project and then get this one cash flowing and let it work its magic. So we would build in sort of the clauses to really make sure people are doing what they're supposed to be doing right into the joint venture agreement.
Who would be the one that was responsible for refi? Probably the money partner, correct?
The money partner has to affect it, right? But this goes back to what I was mentioning earlier. Perhaps now is a good time to touch on it. And that is holding property in trust. So it's a common misconception, but joint venture agreements cannot be registered on title in the province of Ontario. The Director of Titles at the Land Registry Office has refused to allow anything constituting a trust to be registered as an instrument on title, which, is a little unfortunate because it's allowed in other provinces. And this would be a great way to show the public at large can't just buy this property from this person until this instrument is discharged. But we can't do that in Ontario for now. And so we have to rely on the common law and other pieces of legislation to protect ourselves. And so how a joint venture works, basically, for those of you who have not done one or have not had one done properly, is that we have the money partner hold the property in a bare trust. And I'll spare you the legalese, but what this means is the money partner is on title, but they own it for the benefit of the active partner. And trust law in Ontario is complex and way out of scope for me to try and explain to you today. But the end result is the passive money partner is not allowed to do anything with that property without the consent of the beneficial owner, which is the active partner. And so this is governed by a couple of things. Number one, trust law. Trust law, as it's built right into the name, requires a level of trust between people. Mm-hmm. And so we can rely on trust law and the consequences that come from breaching trust to sort of make sure that our passive partner isn't doing anything with the property that they shouldn't be doing. There are civil consequences for breaching trust, right? This could involve a lawsuit. This could involve penalties, and it's not good, right? So here's another thing. As the active partner, who's the one going to the property? Who's the one talking to the tenants? Who's the one even doing a drive-by? So it's you as the active partner. It's probably not your passive partner. So if we see a for sale sign on the front yard, what do? We go right to a lawyer, and that lawyer registers a caution on title, which immediately freezes title for 30 days. Okay? They can't sell anything. And that gives your lawyer enough time to go to court and get a certificate of pending litigation put on title. And what this does is it ties up the property for a further period of time and effectively bars your partner from selling the property or refinancing it. So we can take action if our passive partner is getting squirrely with our asset. And we can rely on the civil consequences that come from breaching trust. But no, what I would put to you is that you're going to know. You're very likely going to know as the active partner in advance of anything happening, right? So when the passive partner is talking to the bank, getting a mortgage, you should be CC'd on those emails, right? You should know. And that will trigger the bank to probably CC you back, right? In reply alls. So if there's going to be a refinance, you might be CC'd on that email. If there's going to be a sale, you're going to see the for sale sign. And if they're going off market, you're probably going to see the post on the off market deals. We're all part of the groups, right? So this is part of the risk you take as the active partner. You can't register on title, so you can't be 100% secure. But this leads to my next point. It's fun to do due diligence on a property, but I encourage all my clients, do your due diligence on your partner. Have conversations that are not about real estate. Don't jump into a deal the day after you meet someone. I've had clients burned by this before, and it's not fun, right? Like money goes out the door, lots of time and effort and energy is wasted, right? We want to be making sure our partners are good partners, people who have done deals or can bring coaching and mentorship to help do or accomplish that deal. If we're partnering with a money partner, that's a little different, right? They're bringing a commodity, which is cash, to the deal. But we still want to get a sense of, how are they going to relate to me? Am I going to be answering phone calls and texts every day? If so, am I okay with that? Is this good enough of a deal to deal with that? Or do I like talking to my passive partner every day? Perhaps that's the case. We want to be doing our due diligence on our partners so that we're not worried about not being 100% secure in our joint venture partnerships as the active partner.
That was a lot of information. I feel like everyone's going to have to like absorb for a little bit. That was great though. Anyone have any follow-ups to that or have questions? Yeah, go ahead. I don't know how to say Ari?
It's Arlie. Yes.
Arlie, okay.
I have a question for you, Shawn. Who typically writes up the JV agreement? Is that, or who meets with the lawyer? Would that be the money partner or the active partner?
Great question. Typically, it's the active partner. And for the simple reason that the active partner usually is the person that actually understands this, right? They understand what a joint venture partnership looks like. They're going to go hire the lawyer. Now, they may not pay the bill, right? The money partner may pay the bill, which is fine. But generally, the active partner is going to hire the lawyer, and the passive partner is going to go seek independent legal advice.
Do you have a follow-up to that, Arlie, or that answered all your questions?
So the wheels are turning. So yeah, I might have one later, but go ahead.
Okay. Anyone else have any questions that they would like to ask? Okay, giving you one more second, guys. No questions? Okay, so I'll ask my next question. So if we could go into, I guess, a little bit more detail on the due diligence part, like what would you recommend to people to actually ask about, ask their partners? Like what kind of questions should they ask, or what kind of information should they collect from their partners?
Sure. Okay. So it really depends on what partner you are. Let's start, assuming we're the active partner. So we're looking for a money partner, which is great. Money is everywhere, right? So we want to make sure that we are getting the right person to come into our deal, because as I mentioned earlier, money is a commodity and it's everywhere. So what we're going to want to ask is, who are you as a person? How risk adverse are you? Are you comfortable if we lost everything? Are you going to be okay? Is this your last bit of savings? Right? You do not want to do a deal with someone who is spending their life savings on your deal, because guess how many phone calls and texts you're getting? A lot, right? And that's a lot of pressure on you, right? So that means that you can't fail. And like I mentioned earlier, we are venturers. These are investments. There's no guaranteed return. And you should, as an aside, never guarantee a return to anyone, because the Ontario Securities Commission is going to knock on your door. So we can't guarantee a return legally or practically. So we don't necessarily want to be doing deals with someone who's spending their entire life savings on that deal. We want to be dealing with someone who is who's got a good job, who's got some cash flow coming in, who's got savings. So I'm going to want to see, hey, how much money do you have in the bank? How much money do you have access to? What do you do, right? If I'm doing a joint venture partner with someone who works, 8 to 10 retail, that might be fine. Maybe they've got savings, or maybe they've got family money, whatever it might be. But if they don't, I'm going to seriously question whether or not I want to do that deal, because I don't know that they're going to be comfortable with losing their savings on this type of deal. But, if you're dealing with someone who's got a profession, who's doing very well, who's got other assets or other investments and has savings, this is the type of person that you want to be dealing with, because they understand that there is risk involved. That's what an investment is, right? It's risk. It's taking risk and being rewarded sometimes, most times, hopefully, for taking that risk. So you're going to want to be comfortable with the money partner and their tolerance for risk. because the less tolerant they are, the more headaches and the less time you're sourcing deals that there's going to be. If we're the money partner, we need to be asking the active partner, what's your experience? Have you done this before? If it's a flip, have you flipped properties before? Do you understand how to calculate construction costs? How did you calculate construction costs? Did you eyeball it? Did you post in a Facebook group and get an answer and then just spit that answer out? Or did you sort of tally up? Okay, how many 2x4s do I need? How many square feet of drywall do I need? How many bathrooms am I replacing? And what are the costs to install a toilet and a vanity and a mirror, etc.? Am I replacing kitchen cabinets? Okay, fine. Did I call up a cabinet maker, or did I go to Home Depot and price out what the cabinets are going to be? Did I call an electrician and a plumber and get a quote? Right? Did you, as the active partner, actually do real due diligence, or are you just estimating? And it's okay if you're just estimating, but that only comes with experience, right? If I've done 10 flips and I've made money on 9 of them, and my guesses or my estimates have been within, plus or minus 10%, then as the passive partner, I'm going to be much more comfortable with your estimate. But if you haven't done a flip before, that's okay, right? But have you done extra due diligence? And if you don't have the experience, do you have the mentorship or coaching to step in and help you if something goes wrong or you don't know what to do, right? We're looking for either credibility or access to credibility, which I'm sure you've all heard before, right? We want to make sure that as active partners, we are credible with what we're offering to our passive partners. And as a passive partner, I want to see that. I want to see that come from my active partner.
Great. Thank you so much. Does anyone have any questions, a follow-up question or a new question that they would like to ask? Everyone's very quiet today. Maybe absorbing all the information you're giving it. Look at
it is a lot.
Yeah, kind of.
It's a lot.
So going back to, you were talking about liens and you're also talking about bare trust. Like, would you be placing a lien if you're using a bare trust? Like, those are two separate, like you wouldn't need a lien, would you, if you're on as a bare trust? Does that make sense?
That's right.
Okay.
Yep, it makes sense. Okay, so a lien is really just evidence that someone is owed something and it's secured against the property. So it's a lien is really just evidence. So, but recall what I said. You're not allowed to register an instrument, which is evidence, on title for anything purporting to be a trust. So if we're registering a lien on title and it's to secure our bare trust agreement, well, you might be able to register, but the land registry office is going to decline that instrument probably within a week. And then you're no better off than you would have been had you not registered. You've just assumed the cost of hiring someone like myself to do so. So no, we're not putting a lien on if we're just in a bare trust agreement. If we've loaned money to the venture and the passive partner hasn't paid us back as they were required to do by the agreement, well, now that's different. Now we've got a loan that is not being paid back. That can be registered on title.
And that would be, though, you're talking about an unsecured loan, right?
Yeah.
Because that would, like, secured, you wouldn't do those kind of things either, because you're already secured.
No, you would register a mortgage on title with a secured loan, but you could try and put a lien on title to show, hey, this person owes me money, and our joint venture agreement says if I don't, if I'm not paid back, I can register a lien on title, and you didn't pay me back, so I'm going to register a lien.
So if you're on title if you're on mortgage, some people would register a lien. That would be okay. I was gonna say, I'm like,
no, the active partner, right? If I'm the active partner and my money partner is supposed to chip in $20,000 for a rental, and they don't. And I'm stuck with contractors knocking on my door for 20 grand and I got to pay it. Well, that's now a loan, right? That's what our, at least something I would draft. That's a loan to the passive partner, which is payable with interest. And if you don't start paying me back with interest, then I'm going to register a lien on title. And that means that when this property is eventually sold, to discharge that lien and give good title to the buyer, you got to pay me back, which we can do very easily by directing the selling lawyer to direct the funds to the person who placed the lien, which in this case would be the active partner.
Mm-hmm, mm-hmm. Okay, perfect. Thank you. That's yeah, that was good. Because I was gonna say I was unsure. It's like because I do a lot of private lending. That's why I was like I would never think to do a lien because I felt like I'm already secured on title anyways.
Right.
So does anyone have any follow-ups or any other questions they would like answered? Yeah, Andrea, you can go, and then April can go.
Yeah, you mentioned that the money partner would be entitled, and the active partner would be the one that actually is actually at visiting the property, so they'll see if the property goes up for sale. What if you have a JV partner, but the property is out of town, so you as the active person, basically you wouldn't be visiting the property? How do you protect it from that person selling the property?
You stay in contact with your passive partner, number one. Number two, find an agent in that city. Pay them $100 to go drive by the property once a week, right? If you are not comfortable with your passive partner, then maybe we should be reconsidering the deal. But if you want to do the trust but verify thing, we'll find an agent, right? You got this property to its highest and best use. Now you're just cash flowing, but you're out of town and you want to trust but verify. Pay someone $100 or whatever you need to do a drive-by. If there's a for sale sign on the lot, well, then that's good money after good. And if there's not, well, then at least you've bought yourself some peace of mind.
Also, I feel like as an active partner, you would probably be pretty involved, even as far away, just because, I mean, most likely you're the one who's managing all the teams. So like what if you're far away, you'd probably have a project or as a property manager there, and you'd be the point of contact because you're the active one anyways. So even your property manager would probably notice like, hey, it went up for sale. How come you didn't tell me? And then you'd be like, oh my God, why didn't you tell? Why didn't I know? You know? So I feel like
tenants would probably point it out to you too if you don't have property management.
Exactly. Yeah. So I think as an active partner, even if you're far away, you probably would be hearing something going on by someone because, I mean, you're the active one. So you're the one with all the connections with everyone, really, right? Your passive partner doesn't really get like that. They're just bringing the money and that's it. So they probably don't have like the direct contacts to everyone, or I mean, they're just not, as in like they may have their contact information, but not actually doing the communications because that's the active person's responsibilities. April, would you like to ask your question?
Yeah, further to that, the active person is the one that's doing the tenant screening, that's working through the process. So they already will have that relationship. And if you've got a good relationship with your tenants, you're saying, if there's a problem with the property or anything, I'm your first contact. Then they would most likely be the one to reach out to you and say, hey, there was a real estate agent or there was an investor coming around looking at the property. Are you guys selling? Because most tenants right now, that's the biggest turnover for them. There's investors constantly buying properties and the tenants don't even know half the time who owns the property and who to pay rent to, unless they've got somebody who's properly running the management. But anyways, my question, going back to my question, it had to do with if, for example, the contractor you hired as the active partner isn't getting paid, and as the active partner, you end up paying it using your credit card. The interest rate on that credit card, is that not the interest that should be paid back plus the principal?
Well, whatever you agree to pay back is what you agree to pay back. So, or to charge in this case. So, typically in my agreements, I have it at 5%. If you choose to pay for it on your credit card, well then, you might be paying 18 or 19 points on that, but you're only going to recover 5 from the passive partner, because how you finance that is on you, right? You had to bring a loan. That's unfortunate. That's not part of the deal, right? And we've had to invoke certain sections of the agreement that were there just in case this happened. But generally, how you choose to offer that loan is going to be on you.
Do you have a follow-up for April about it, or did that answer your question?
That answered it, but I think part of your JV agreement includes your exit clauses, does it not? Like if one partner wants out of the deal, this was what will happen. Is that not what is included? Okay.
Yeah, but that's a separate issue, right? Like just because, you can want to exit a deal, but that's not necessarily tied to not having enough money to pay for your contractor. Exiting is a difficult conversation to have because everyone plans on staying, but then things happen, right? People have kids, people get married, other investments don't work out. Maybe, I'm earning a 20% return on investment, but I got a chance to earn 50 somewhere else, right? And I want to pull my capital out. There are all sorts of reasons why people might want to leave early, right? We generally set a term, right? 5 years is typical. Sometimes it's 3, sometimes it's 10, whatever you want it to be. We set a term. And then we have an early buyout provision, right? And, if it's me, if I'm drafting, I'm introducing some sort of negative consequence for getting out, right? If you're the passive partner and you want out early, well, that's detrimental to the active partner. And that's not what the active partner agreed to. So generally what I say is, here's what we're going to do. We're going to get a valuation of the property. We're going to get an appraisal in. And then depending on how far into the deal, I'm going to buy you out at a certain percentage of that appraised value, right? Like if this is a 5-year deal and I put all this time and effort as the active partner into bringing this property up to its highest and best use, and now I'm expecting the cash flow, and that's my reward for 5 years, and you bounce early, well, I'm going to want much higher split on the equity than you get, because that's just not fair, right? Like that's not what I agreed to. So, it might be you get to be bought out for 90%. I go find a new partner who will come in with that amount of money to replace you. And then I will continue with my cash flow, or maybe I have the cash, or maybe I come in and I buy you at 90%, and I've just bought myself an additional 10% of equity, and then I can figure out what to do from there in terms of finding another partner or not.
Great,
thank you.
Do you have a follow-up to that, April? Okay. I'm not sure Andre had his hand up. I don't know I think maybe you answered it, or do you still? Yeah.
It got answered, thanks.
Oh, okay, perfect. Anyone else have any questions for Shawn? Sure, go ahead.
Yeah, hi Shawn. Are there different types of JVs? Like I think that the premise of what we're talking about is more so to like someone finds a property, someone does the provides the money. But what about JVs? Let's say if you're doing a wholesale deal, if you want to have a partnership with that, do you have any type of JVs for that?
Yeah, it's just a much simpler JV. If you're wholesaling or even wholetailing, you don't necessarily need nearly as in-depth of an agreement, because number one, if you're wholesaling, no one owns anything, so we're just agreeing and how that wholesale fee is going to be paid. If we're wholetailing, a little more complex, right? I'm in a wholesale deal right now. Just closed on a cottage, and we're listing it on the market if we can't sell it off market here soon. A little bit more complex because now we've got something on title. Right? We've got a person on title. So we're going to want something a little bit more secure than a wholesale deal. but it's still short term, right? Like I don't want to own this property 60 days from now. So, it's pretty short term. So that's obviously a lot different than a 5-year project. So yeah, like I can draft anything you want. And that's the beauty, right? That's the beauty of contract law. We call it private law for a reason. You can do anything you want, anything you can agree to and can put into writing, as long as it's not unconscionable, illegal, or unenforceable, you can agree to it, right? Your other person's gonna need independent legal advice, but this is why creativity matters in this space. If you can come up with it, then I can draft it.
Okay, thank you.
Great, thank you. Do you have a follow-up, Arlie, or that's perfect? That was good. Oh my God, Shawn, thank you so much. You gave us lots of valuable information. I know everyone got really good information from you, so thank you so much for coming on.
You're welcome.
And
it was my pleasure.
Thank you. And would you like to give it some kind of contact information?
Sure. Let me just put it into the chat. Best way to reach me is by email, which I put there. So you can reach me there and I'll set up a time with you. I'll send you my link to book a time to chat. We can talk about your project, what you need, and how I can bring some value to you, right? Like that's my value proposition, is I understand your deals. So any lawyer can close a real estate transaction, but not every lawyer can really understand and help you, right? Like VTBs, that could be a whole other day, and that's actually a great topic to talk about. VTBs are so valuable in the real estate investing space, but they're so complicated from the legal side because, as I mentioned earlier, there's some conflict of interest matters that we've got to address. So you want to talk about things like that, like joint ventures, closings, strategies, send me an email. We'll set up a time to chat. We'll chat for a few minutes, see what I can bring, see how I can help, and I'd be delighted to do so.
Awesome. Thank you so much. And yeah, so it's Shawn at carsonlaw.ca, just in case people don't see it in the comments. Thank you so much.
I see sorry, Diana. I see April's asked about location. We serve the entire province of Ontario. There's no place that we can't help you out on. That's because we operate virtually with our clients. So you can live in Thunder Bay if you want, or Windsor, or Ottawa, or as far north as you want. I can help you because we're going to get on a call like this and we're going to sign like this.
Yeah, I'm sure this has actually helped you widen your circle a lot more, because before everything was coming into the office, really the circle is quite small. Now that we've had to go virtually, it really helps a lot more, because then you can make sure like that, like, or if you like, I think, if you have like the one lawyer, at least you can stick with the one that you like, because at least now we're all in, you don't have to worry about it.
The pandemic really forced the Law Society to get current quick, because law rules are antiquated and they're not keeping up with the times. And even the rules that are new don't keep up with the times. Like convocation at the Law Society just changed a very important rule last week, and it has caused drastic consequences to real estate investors by taking out the ability for lawyers to represent both a mortgage investment corporation and a borrower in a transaction. Now you need 2 lawyers, which is, I don't love that rule. It's really complicated the practice, and it's caused, my clients to have to incur additional expense. But that's the new rule. So the Law Society, they're doing what they're doing, but the pandemic forced them to get current. So, now we're allowed to sign virtually, so I can get on video. I got to see you signing. I got to check your ID. I got to make sure it's you, right? But we can sign virtually, which has opened up, our business to the entire province.
That's amazing. Yeah. Thank you so much, Shawn. Thank you everyone for coming on. It was great to see everyone here, and we'll definitely be, and I think next month, Shawn will be back on, right? We're going to be talking about wholesaling, I believe it is.
Yeah, I think I've got 1 or 2 future dates set up. So I'm sure there's going to be plenty of topics to chat about. There's so many areas of real estate investing law that there's so many questions about, right? And that's what I'm here for.
Awesome. Thank you so much. Thank you for everyone for joining. I hope everyone got a lot of value, and we'll see you on the next Ask the Experts. Thank you, everyone. Bye, everyone.
Thanks, Diana.
Bye.
Bye, everyone.
No
Thanks,
problem.
guys.
Thank you. This was really helpful.
Thanks, Shawn.
No problem. Glad everyone enjoyed.